The judge mocked the woman before the entire courtroom. Moments later, his face turned pale. The gavel came down before Margaret Hollis even finished saying her name. She had been standing at the podium for less than 40 seconds. Her folder was open. Her hands were steady. But Judge Calvin Hurst was already looking past her, already scanning the docket sheet like she was a smudge on a window he needed to see through. "And you have no attorney representing you today," he said. "Not a question, a verdict." "No, Your Honor," Margaret said. "I am representing myself." The courtroom was full. It was a routine civil docket day in Clover County, and the gallery benches held a mix of lawyers in pressed suits, people waiting for their own cases, a couple of law clerks, and a court reporter named Gloria who had been typing in that room for 11 years and had seen nearly everything. The wood-paneled walls absorbed the sound of shuffling papers and low whispers. The ceiling fans turned slowly. The smell of floor polish and old paper hung in the air. Margaret Hollis was 54 years old. She had driven 40 minutes to get to this courthouse. She had woken up at 5 in the morning, ironed her navy blue blazer, eaten half a piece of toast because her stomach would not allow more, and walked out of her rented apartment with a rubber-banded folder tucked under her arm and 17 years of careful living behind her. She was a retired schoolteacher. She had taught 8th grade history and civics in a public school for 22 years. She knew how institutions worked. She knew how power moved through rooms. And she knew, the moment Judge Calvin Hurst looked at her over the rim of his reading glasses with that particular brand of boredom that doubles as contempt, that he had already decided what she was. A nuisance, an amateur, a woman who did not understand where she was. He picked up her filing and held it the way you hold a piece of paper that has gotten wet. He read the top line. He set it down. "Ms. Hollis," he said, "this is a courtroom." "Yes, Your Honor." "You have filed a civil complaint against Meridian Savings and Trust, a bank." He said the word bank the way people say it when they want to make the other person feel small for challenging one. "You are alleging wrongful foreclosure. You are seeking damages. And you have done all of this." He paused here, and the pause was deliberate, and the room felt it, without the assistance of a licensed attorney. "That is correct, Your Honor." He leaned back slightly. "Not far, just enough. And what did you do before you decided to take on a financial institution, Ms. Hollis? If you don't mind me asking." She did mind, but she answered, "I was a school teacher, Your Honor, for 22 years. He nodded slowly, the nod of a man tolerating something. A school teacher. He looked briefly at the gallery, and several people looked back at him, and there was a small, terrible moment of shared understanding that moved between them like a current. "Well, that explains the filing." Someone in the back row made a sound, not quite a laugh, but close enough. Margaret's jaw tightened. She felt it tighten. She had practiced not reacting. She had stood in front of bathrooms' mirrors for 3 evenings and practiced keeping her face calm and her voice level and her hands still, because she knew this was coming, had known it the moment she decided to walk into this courtroom without a lawyer beside her. She had known a man like this would be sitting at that bench. Men like this were always sitting at benches like that. She breathed in, she breathed out, she kept her eyes forward. "Your Honor," she said, "I would like to submit my documentation for the record." "In time," he said. He had not finished. He picked up her filing again and began to read from it, not all of it, pieces, selected pieces. He read them in the tone of a man reading a child's attempt at writing an essay, slowly, with unnecessary emphasis, letting the words hang in the air long enough for their imperfections to become visible. He commented on her phrasing. He raised an eyebrow at one of her citations. He asked her, in a voice that was almost kind but was not kind at all, whether she understood the difference between a procedural filing and a substantive argument. She said she did. He did not look convinced. He told her that her complaint had several procedural deficiencies. He listed them. Some of them were real deficiencies. She had already known about them and had addressed them in the supplemental pages she had attached. He had not reached the supplemental pages. He told her she had 30 days to retain legal counsel, or the case would be subject to dismissal. He told her, and this was the part she had not fully prepared for, the part that got past the mirror rehearsals and found the soft place underneath, that perhaps this matter was beyond the scope of what she could reasonably manage on her own, that these things were complicated, that there was no shame in seeking professional help, that the law was not something a layperson could simply walk into and expect to command. He said it the way people say things when they want you to be grateful for the cruelty, wrapped in a tone of patience, dressed up as advice. The court reporter Gloria had slowed her typing, not stopped, but slowed. An attorney named Derek Paulson, who was sitting in the gallery waiting for a completely different case to be called, had been looking at his phone when the hearing started. He was not looking at his phone anymore. Margaret Holly stood at that podium and absorbed every word Judge Calvin Hurst said. She let him finish. She waited until the pause after his last sentence had fully settled, until the room had gone quiet in the way rooms go quiet when a performance has just ended. Then she said, "Your Honor, I'd like to submit Exhibit A." He looked up. "And Exhibits B through Q," she said, "if it pleases the court." The courtroom did not erupt. It did not gasp. It went very still in the specific way that rooms go still when something is about to shift, and everyone in the room can feel it, but no one is yet sure what it is. Judge Calvin Hurst looked at her. He looked at the folder under her arm, which was thick and organized and clearly labeled, which he had noticed from the beginning but chosen to dismiss, because the woman holding it was wearing orthopedic shoes and had no law degree. "Exhibits," he repeated. "Yes, Your Honor." He gestured, "Proceed." She walked the documents to the clerk. She had organized them the night before, alphabetized by exhibit label, each one separated by a colored tab. The clerk, a young woman named Donna who had been working in that courthouse for 3 years, received the stack and looked at it with wide eyes and said nothing. The first exhibit went to the judge. Margaret walked back to the podium. She folded her hands on the surface of it. She waited. The courtroom waited with her. And Judge Calvin Hurst, who had been on the bench for 19 years and who had learned long ago how to keep his face composed and his reactions hidden, began to read. He read the first page. He turned to the second. His hand, which had been resting loosely on the surface of his bench, went flat and still. Margaret Hollis watched his face. She had been watching it from the moment she walked in. She had been watching it through every comment and every pause and every borrowed laugh from the gallery. She watched it now as something moved behind his eyes, something that started as confusion and moved, slowly but visibly, toward a place that looked very much like alarm. He had not expected this. He had expected a schoolteacher with a grievance and a messy folder and good intentions, and no real weapon. He had not expected 17 months of research. He had not expected a woman who had spent her evenings at a public library, who had learned to navigate public records requests, who had printed and read and annotated Federal Circuit Court rulings until the margins of the pages were full of her own handwriting. He had not expected someone who had been paying attention her entire adult life and had simply been waiting for the moment when paying attention would count for something. He turned to the next page. His face did not go pale in the dramatic way that faces go pale in movies. It was quieter than that. It was more honest than that. The color left his face the way warmth leaves a room when a window is opened in winter, gradually, completely, and with no possibility of pretending it had not happened. The court reporter, Gloria, was watching him. The attorney in the gallery, Derek Paulson, was watching him. Donna the clerk was watching him. Everyone in Courtroom 7 was watching. Judge Calvin Hurst read the documents of a retired schoolteacher in a navy blue blazer, and no one said a word. Margaret Holly stood at the podium, Her hands were still folded. Her face was still calm. She had practiced for this too. The morning Margaret Hollis first walked into that bank, she had not gone looking for a fight. She had gone looking for an explanation. It was a Thursday in early October, 16 months before she would stand at that courtroom podium, and she had come home from a grocery run to find a notice taped to her front door. Not slipped into the mailbox. Taped to the door, as if whoever put it there wanted her to see it the moment she arrived and had no particular interest in being subtle about it. She had set her grocery bags down on the porch step. She had peeled the notice off carefully, because even in shock she was someone who did things carefully. She had read it 3 times. It was a foreclosure notice. Not a warning, not a late payment reminder. A foreclosure notice, dated 2 weeks prior, referencing a property address that was her home. The home she had bought outright 11 years ago with the money from her mother's estate. The home she had owned with no mortgage, no loan, no lien, not a single financial institution with any claim to a single square foot of it. She had sat down on the porch step next to her grocery bags and read it a 4th time. Then she had gone inside, put the groceries away, made a cup of tea, and called the bank. What followed was not a resolution. It was a labyrinth. She was transferred 4 times in the first call. She was told the matter was being reviewed. She was told she would be contacted within 5 to 7 business days. She was told, by a man whose voice carried the particular exhaustion of someone who says the same sentences to distressed people all day long, that she should not worry. 5 to 7 business days passed. No one contacted her. She called again. She was transferred again. This time she kept notes, a yellow legal pad, the date and time of each call, the name of each person she spoke to, what they said. Some of them gave her names. Some gave her initials. One gave her a reference number that turned out, when she tried to use it in a follow-up call, to correspond to a completely different account belonging to someone in a different county. She was not panicking. She was paying attention. That was the thing about Margaret Hollis that people who underestimated her never got to see in time. She did not move fast. She did not make noise. She did not post angry things online or call a local news station or sob into a phone to someone's supervisor. She wrote things down. She asked questions and wrote down the answers, and then asked follow-up questions based on the answers. She was methodical in the way that good teachers are methodical. The ones who understand that a student who is confused needs information delivered in the right sequence, not delivered loudly. She went to the bank in person. She brought her deed, clean title, no liens, the original documents which she had kept in a fireproof box in her bedroom closet since the day the purchase was finalized. The bank manager, a man named Oliver Webb, received her in his glass-walled office and looked at her documents and told her he could see there had been some kind of administrative confusion. He used the word confusion 3 times in 8 minutes. He did not use the word error. He did not use the word mistake. He told her the matter would be escalated and resolved. She asked him what escalated meant in terms of a timeline. He said he was not able to give her a specific timeline. She asked him who she could speak to who could give her a specific timeline. He said he would look into that and get back to her. He did not get back to her. She went home. She made another cup of tea. She sat at the kitchen table with her legal pad and her deed, and a copy of her property tax records, which showed 11 consecutive years of paid taxes on a property she owned free and clear. And she began to think about what she actually knew, not what she feared, not what she assumed. What she actually knew, factually, provably, from documents that existed in the physical world. What she knew was this: she owned her home. The bank was claiming a right to that home. That claim was wrong, and the bank knew it was wrong because she had shown them the proof, and they had responded not with correction but with language designed to make the problem feel foggy and manageable, and like something that would sort itself out if she waited long enough. She had taught 8th graders for 22 years. She knew what it looked like when someone was hoping you would give up and go away. She was not going to give up and go away. She filed a public records request with the county clerk's office the following week. She requested everything filed under her parcel number over the past 18 months. She requested the bank's original filing. She requested the documentation trail. What came back to her, 3 weeks later, in a thick envelope that she opened at her kitchen table on a Tuesday afternoon, changed everything. Buried in the bank's own internal paperwork, the paperwork she had obtained legally, through a public records request that the bank had not anticipated anyone filing, was a document she had to read twice before she fully understood what she was looking at. It was an internal audit flag, filed by someone inside Meridian Savings and Trust, dated 8 months before the foreclosure notice appeared on her door. The flag noted a data entry error, a transposed parcel number, that had caused a property to be incorrectly linked to an account in default. The property incorrectly linked to that account was hers. Someone inside that bank had caught the error 8 months before they sent her a foreclosure notice. Someone had flagged it. Someone had written it down. And then the foreclosure had proceeded anyway. She set the document down on the table. She put her hands flat on either side of it. She looked at it for a long time. Then she opened a new legal pad, wrote the date at the top of the first page, and began building her case. Over the following 14 months, she sent public records requests to 3 separate agencies. She contacted the State Banking Commission, which, after reviewing her initial submission, opened its own inquiry. She found, through the Commission's publicly accessible database, 2 other individuals who had filed similar complaints against Meridian Savings and Trust in the past 4 years. She reached out to both of them. One did not respond. The other, a retired postal worker named George Clifton, who lived 2 counties over, agreed to provide an affidavit. She found a federal circuit court ruling from several years prior that had established clear precedent for wrongful foreclosure liability in cases involving documented institutional error. She printed the full ruling. She read it 3 times. She annotated it. She identified the specific passages that mirrored her situation with a closeness that did not feel like coincidence. She taught herself, from library books and legal aid websites, and one very patient librarian named Francis who spent several afternoons helping her navigate court databases, how to format a civil complaint. She drafted it 4 times. She read each draft aloud to herself in her living room. She cut what was redundant. She added what was missing. She cited her sources correctly. She submitted the complaint on a Wednesday morning in early spring. She drove to the courthouse, parked in the public lot, walked to the filing window, and handed it across the counter. The woman behind the counter stamped it without looking up. Margaret walked back to her car. She sat in the driver's seat for a moment. She was not triumphant. She was not relieved. She was simply someone who had done the next step, which was the only way she had ever known how to move through hard things, one step at a time, documented and without expecting applause. She drove home, she made tea, she waited. And 6 weeks later, she received a notice that her case had been assigned to Courtroom 7, and that her hearing was scheduled before Judge Calvin Hurst. She looked up his name that same evening. She found his record, 19 years on the bench, a reputation for efficiency, no major misconduct rulings, several legal commentary pieces that mentioned his impatience with pro se litigants, people who represented themselves without an attorney. She sat with that for a moment. Then she went to her bedroom closet and got out a new rubber band, because the one on her folder had gone loose, and she wanted everything to hold together when she walked into that room. When Exhibit C landed on Judge Calvin Hurst's bench, something in the room shifted. It was not a loud shift. There was no gasp, no dramatic intake of breath, no moment that would have looked cinematic from the outside. It was quieter than that. It was the kind of shift that happens when people in a room realize, one by one, that what they assumed was true is not, and the realizing spreads from person to person like a slow change in temperature. Exhibit C was an internal email. It had been obtained by Margaret Hollis through a public records request, a fact that was noted in her documentation, with the request number and the date of the response. The email was between two employees of Meridian Savings and Trust. It had been written 8 months before the foreclosure notice appeared on Margaret's door. The subject line read, "Ray, Holly's property, do not proceed." The body of the email was 4 sentences long. It identified the error. It named the parcel number that had been incorrectly entered. It confirmed that the property was not linked to any active loan account. And it stated, in direct language that left no room for interpretation, that the foreclosure process that had been initiated on that property should be stopped immediately. The email had been sent. It had been received. It was in the bank's own records. And then the foreclosure had proceeded anyway. Judge Calvin Hurst read that email on his bench in Courtroom 7, and the court reporter Gloria watched his right hand press flat against the surface of the bench, and Derek Paulson in the gallery leaned forward until his elbows were on his knees, and the clerk Donna stopped pretending to sort papers. Margaret Hollis stood at the podium. She did not speak. She understood, with the patience of someone who had spent 22 years knowing when to let a moment land without interrupting it, that this was not the moment for words. The judge turned to Exhibit D. Exhibit D was the State Banking Commission letter, dated 4 months prior, confirming that an inquiry had been opened into Meridian Savings and Trust's foreclosure practices following a complaint submitted by one Margaret Alois Hollis. The letter named the case number. It named the reviewing officer. It noted that the inquiry was active and ongoing. The judge set Exhibit D down slowly. He picked up Exhibit E, which was a copy of the Federal Circuit Court ruling she had found, the one that established precedent for wrongful foreclosure liability in cases of documented institutional error. She had tabbed the relevant passages in yellow. The tabs were neat and evenly spaced. She had measured them. He read the tabbed passages. He turned back to Exhibit C. He looked at the email again. The thing about Judge Calvin Hurst, the thing that was now becoming visible to everyone in that room, was that he was not a stupid man. He had been on the bench for 19 years. He knew how to read documents. He knew how precedent worked. He knew what it meant when a bank's own internal records confirmed a known error and the foreclosure proceeded regardless. And he knew what it meant when that fact was established through properly obtained documentation and paired with an active regulatory inquiry and a directly applicable federal ruling. He knew exactly what he was looking at. What he had not known 40 minutes ago, when a woman in orthopedic shoes had walked up to his podium without a lawyer, was that she knew it too. He set Exhibit E down. He looked at Margaret Hollis. She looked back at him. Her hands were still folded on the podium. Her face was still calm. She had the expression of someone who has been waiting a long time for a specific moment, and now that it has arrived, is in no hurry to rush it. "Ms. Hollis," he said, his voice had changed. It had lost its performance quality. It was flat now, careful. "Where did you obtain Exhibit C?" "Through a public records request filed with the county clerk's office," she said. "The request number and the date of the response are documented on the exhibit cover sheet." He looked at the cover sheet. "And the State Banking Commission letter," he said, "Exhibit D." "I filed a consumer complaint with the commission 14 months ago," she said. "That letter is their confirmation that an inquiry was opened. The case number is listed." He was quiet for a moment, the kind of quiet that has weight to it. "And the federal ruling," he said. "Exhibit E," she confirmed. "The relevant passages are tabbed. The full ruling is attached as a supplemental document behind the main exhibits." He turned to the supplemental document. He found the full ruling. He looked at it. He did not read the whole thing. He did not need to. He had enough. Derek Paulson in the gallery had taken a small notebook from his jacket pocket and was writing in it. Gloria, the court reporter, was typing at her normal pace again, but her posture had changed. She was sitting straighter. "Ms. Hollies," the judge said, "you mention exhibits B through Q. Are the remaining exhibits consistent in nature with what I've reviewed so far?" "Yes, Your Honor. They include 2 affidavits from individuals with documented experience of similar administrative errors by the same institution, property tax records confirming my ownership over 11 consecutive years, correspondence from 3 separate bank employees acknowledging the error in written form, and the original deed showing clear title with no liens." He was quiet again. The courtroom was very still. "Written acknowledgement from bank employees," he said. "That's Exhibits F, G, and H, Your Honor." He found them, he read them. They were emails and 1 internal memo. Each one confirmed knowledge of the error. Each one was dated. Each one carried the name of the person who had written it. He set the last one down. He looked at Margaret Hollies for a moment that lasted longer than most moments in that courtroom lasted. And in that moment, something passed between them that was not comfortable and was not reconcilable, and was simply the truth arriving at the bench the way it eventually always arrives, without announcement, without apology, and with no interest in accommodating the person who had not expected it. He reached for his calendar. "I am granting a continuance," he said. "Full evidentiary hearing. I will set a date." He named a date 6 weeks out. He confirmed it with the clerk. He did it in the voice of a man who was executing a procedure, because procedure was the only ground left to stand on. "Your documentation will be entered into the record in full," he said. "All exhibits, A through Q, and the supplemental materials." "Thank you, Your Honor," Margaret said. She closed her folder. She refastened the rubber band. She did not look at the gallery. She did not make eye contact with anyone. She gathered her things from the podium with the same careful movements she had arrived with, and she walked to the side of the courtroom where she would wait for the clerk to finalize the scheduling. Derek Paulson watched her sit down. He looked at his notebook. He looked at the bench, where Judge Calvin Hurst had already moved on to the next case in the docket, his voice back to its normal volume, his manner back to its practiced authority. Paulson wrote one more thing in his notebook. He looked at it. Then he capped his pen and put the notebook back in his pocket and waited for his own case to be called. In the back of his mind, in the part where attorneys file things they will think about later, he filed Margaret Hollies. Margaret sat on a wooden bench in the hallway outside Courtroom 7 and ate the second half of the peanut butter sandwich she had packed that morning. She had been in the courthouse for 2 hours and 40 minutes. She was not shaking. She had been afraid she might be shaking afterward, because she had been afraid that once the room was no longer watching her and the performance of calm was no longer required, her body might let go of what it had been holding. But she was not shaking. She was tired in the specific way that comes after sustained concentration, and she was hungry. And the sandwich was dry because she had forgotten to pack a drink, and the hallway smelled like floor polish, and she ate the sandwich in 4 bites and watched people walk past and thought about nothing in particular. A woman in a gray suit walked by and then stopped and came back. She looked at Margaret for a moment and said, "Were you just in Courtroom 7? "Yes," Margaret said. The woman looked at her for another moment. "I'm an attorney," she said. "Administrative law. I was waiting for a hearing and I heard part of your case." She paused. "You did well in there." "Thank you," Margaret said. The woman nodded once, as if deciding something. She opened her bag, took out a card, and held it out. "I'm not taking new cases right now," she said, "but I know someone who is, if you want a referral." Margaret looked at the card. The woman's name was Patricia Graves. Her firm was listed below her name. "I appreciate that," Margaret said. Patricia Graves nodded again. She walked away down the hallway without looking back. Margaret looked at the card for a moment. She tucked it into the front pocket of her folder, inside the rubber band. She finished her sandwich. She crumpled the wax paper neatly and put it in her bag. She sat there a little longer, watching the light come through the high courthouse windows. It was mid-morning. She had the rest of the day. She had planned it that way, not because she had been certain the hearing would go well, but because she had learned, over the past 14 months, that the days when important things happened needed room around them. Room to sit and be still and let the weight of what had happened settle without immediately having to carry it somewhere. She thought about her mother's house. Her house. The house that had been in foreclosure proceedings for over a year on paper, even though it had never, not for a single day, stopped being hers. She thought about the kitchen where she had grown up, and the porch step where her mother used to sit in the evenings, and the bedroom where she had slept as a child, and returned to sleep as an adult, and the yard that was hers, and the deed that was hers, and the 11 years of property taxes that were hers, documented on paper, real in the world, true regardless of what anyone had tried to impose over the top of that truth. She thought about Oliver Webb, the bank manager, who had said the word confusion 3 times in 8 minutes and had not called her back. She thought about the first phone call, and the reference number that belonged to someone else's account, and the 7 months she had spent building a file that she had been told, by people who were supposed to know better, was unnecessary and premature, and not how these things were handled. She was not angry sitting there on that bench. Anger was something she had used during the long months of waiting, had reached for it like a tool when patience threatened to collapse into despair, had let it steady her when discouragement came. But sitting here now in the hallway, with the card of Patricia Graves in her folder and Exhibit Q entered into the court record, she did not feel angry. She felt something quieter than anger, something that did not yet have a simple name. She felt the particular satisfaction of someone who had been correct, and had not given up on being correct when being correct was inconvenient and costly and lonely and slow. The hearing was set. The documentation was in the record. The State Banking Commission inquiry was active. The precedent was established. The bank's own internal records confirmed the error. She had not done any of this because she expected to win easily. She had done it because it was true, because something true had happened to her, and she had decided that truth was worth the work of proving it, even when no one was watching, even when the work was tedious and the process was slow, and the people she called did not call back. She reached into her bag and found a pen and opened her legal pad to the next blank page. She wrote the date at the top. She wrote down everything she needed to do before the next hearing. Call Patricia Graves's referral. Request the bank's full foreclosure file under the pending inquiry. Follow up with the commission's reviewing officer. Obtain certified copies of all exhibits. She wrote neatly and without hurry. The hallway was quiet. The floor polish smell had faded. She had 6 weeks. That was enough. The settlement arrived on a Tuesday, 6 months after the hearing, in the form of a call from the attorney Margaret had retained 2 weeks after that courthouse hallway. His name was Neil Barker. He was 41 years old, had been practicing administrative and property law for 15 years, and had a reputation for being methodical and precise and very difficult to rush. He had taken her case at a reduced rate after Patricia Graves's referral, and he had reviewed her documentation file without speaking for almost 40 minutes during their first meeting, and then he had looked up and said simply that she had done a very thorough job. She had thanked him and asked what they needed to do next. That was all Neil Barker had needed to know about her. He called her on a Tuesday morning while she was at a school substitute teaching 6th grade. She felt her phone vibrate in her jacket pocket during a class discussion about the American Revolution and excused herself to the hallway. He told her the bank had proposed settlement terms. She asked what the terms were. He told her. The home's title would be formally cleared of all foreclosure proceedings and restored to her name, clean, with documentation filed with the county clerk by close of business the following Friday. The bank would cover all legal fees she had incurred. And there was a financial amount, which was sealed under the settlement agreement's confidentiality clause, which meant she was not required to disclose it, and he could not recommend that she do so, that he described as more than fair, and that he personally found satisfying. She was quiet for a moment. "Are they admitting the error?" she said. He was quiet on his end too for a beat. "The language of the settlement does not include an admission of wrongdoing," he said. "That's standard. I want to be honest with you about that." She already knew that was how these things were phrased. She had read enough by now to know. "But the error is documented," she said, "in the record." "In the court record," he confirmed, "and in the Commission's inquiry file, which remains open independent of this settlement." She looked at the classroom door. Through the small window she could see her students talking to each other, some of them, the way students do when a teacher steps out. One boy was drumming on his desk with a pencil. A girl near the back was laughing at something. They were fine. "I'll accept the terms," she said. Neil Barker said he thought that was the right decision and that he would handle the paperwork. He asked if she had any other questions. She said no. She thanked him. She stood in the hallway for a moment after the call ended. The boy behind the door was still drumming. She could hear the soft, irregular rhythm of it. She put her phone back in her pocket. She went back into the classroom. The students looked up. The drumming stopped. "Where were we?" she said. It was not a question. "Lexington and Concord," said a girl in the front row. "Right," said Margaret. "The shot heard around the world." She picked up where she had left off. The class ran to the bell, and when the bell rang, she dismissed them and gathered her things and sat down at the desk while the room emptied. The room went quiet. She sat in the quiet for a moment. The windows faced east. The morning light was still good. Then she thought about Judge Calvin Hurst. She had not thought about him much since the hearing. She had thought about the case, about the documents, the timeline, the next steps, but she had tried not to think too much about him specifically, because thinking about him too much made the anger come back, and she had found that anger, while useful as a tool, was not useful as a passenger. It made the work harder. It made the thinking cloudier. She had learned over those 14 months to feel it when it came, and then set it aside and return to the documents. But she thought about him now. She thought about the way he had read her filing aloud, piece by piece, with that tone. The way the pause had worked. The way the gallery had responded. The way he had said, "Perhaps this matter is beyond your capacity to pursue," with his voice calibrated to sound like concern. She thought about his face when he read Exhibit C. She was not glad he had been humiliated. That was not the right word for what she felt. She was not interested in humiliating people. She had been interested from the very beginning in a single thing: getting back what was true, making the record reflect what was real. But she would be lying to herself if she said the moment had not mattered. The moment of watching a man who had decided, inside of 40 seconds, that she was not worth taking seriously, watching him encounter, one tabbed exhibit at a time, the precise and detailed evidence that he had been wrong, that had mattered. Not because she needed it, but because it was the truth doing what truth does when you give it the right tools and the time. She had given it both. She heard through the open door that the hallway was settling into the low hum of passing period traffic. Lockers, voices, sneakers on tile. 3 months after the settlement closed, she learned from an attorney acquaintance that Judge Calvin Hurst had received a formal inquiry from the State Judicial Conduct Commission. She had not filed that inquiry. Others had. 3 individuals who had been in the courtroom that day and submitted written statements to the commission. The court reporter's transcript had been included in the commission's review. The inquiry did not result in his removal from the bench. It resulted in what the commission called a formal counseling, a required training in courtroom conduct and the rights of pro se litigants. It was entered into his professional record. She heard about this second or third hand, through a conversation that reached her without her having sought it, and she received the information with the same expression she received most things, without drama, without visible satisfaction, without comment. She had not gone to court to change him. She had gone to court because her home was hers. That was the beginning and the end of it. The title was cleared. The deed was recorded. The property was hers, on paper in the world in the county clerk's office, as it had always been. She went home to the house. She stood in the kitchen. The afternoon light came through the window over the sink the way it always had, at that angle, at that hour. She put the kettle on. She got out 2 cups out of habit and then put one back. She drank her tea standing at the counter, looking out at the yard. The yard needed attention. The grass had gotten long and the rosebush along the back fence had grown over the wire. She would need to address that this weekend. She washed her cup, she dried it, she put it away. She went to her bedroom closet and opened the fireproof box. She placed the new, certified copy of her deed inside, next to the original, and closed the lid. She had kept a rubber band around her folder for 14 months. The folder was on the desk in the second bedroom, which she used as a home office. She picked it up. She looked at it for a moment. She removed the rubber band and dropped it in the drawer. She did not need the folder anymore. The work it had held was done. The truth it had carried had made it to where it was supposed to go. She turned off the desk light. She went to bed at her regular time. She slept